gets a 10% impairment rating or a 10% loss of use to their arm, your arm is worth 240 weeks. So the way this works is that you take 10% of 240, 24, and you multiply that by your compensation rate, resulting in a lump sum amount. Now, when I talked about the importance of making sure the compensation rate is correct, this is another reason why, because it will have a lot to do with your claim for the permanent injury. This is why in our office, we place priority on making sure that the compensation rate has been calculated correctly. It will make a big difference in the benefit for a permanent injury. The other part of a permanent injury is when the injured worker is unable to return to work in any employment making the same amount of money as they did before they got hurt. And remember, you're entitled to receive your compensation rate as long as you're out of work. And if you end up with permanent restrictions and your employer cannot comply with those restrictions, in other words, they don't have a job for you within those restrictions, and if you can't find other employment that pays you close to what you were making before, then you're entitled to receive your weekly compensation payment. And in North Carolina, you're entitled to receive that for the rest of your life or as long as you're disabled. Now, this is again why it is important that your compensation rate be calculated correctly, because in this situation, this is what you're going to live on potentially for the rest of your life. I want to talk now about hidden claims. And these are benefits that I believe adjusters either do a poor job explaining or don't explain at all. And these are very important because, remember, when you're injured on the job, you have a number of out-of-pocket expenses that are related to the injury. And workers' compensation is supposed to reimburse the injured worker for their expenses. The first hidden claim is reimbursement for mileage. An injured worker is entitled to receive reimbursement for mileage, for travel back and forth to the doctor, from their home to the doctor, and travel for vocational rehabilitation. And they're entitled to receive reimbursement or payment per mile if they travel more than 20 miles round trip. For example, 50 cents per mile. And I cannot tell you how many folks I've spoken with that did not know that they were entitled to mileage reimbursement, when in fact they've been paying out of pocket for gas and other expenses so they can go back and forth to the doctor. Another hidden claim, or a claim that the adjusters will rarely bring to your attention, involves an incorrect compensation rate. We find often that after we audit the compensation rate, that we find an underpayment, or that the adjuster has underpaid the injured worker. There's two common errors that adjusters make when determining the correct compensation rate. The first involves including overtime. When we spoke earlier about how your compensation rate is determined, we mentioned that it's based on your average gross earnings for the period of time before you got hurt. And that average gross earnings include payment for any overtime or any other amount, any other payment that are made in lieu of wages. We see often that adjusters, instead of including overtime, may base the compensation rate on what that worker was paid per hour for a 40-hour work week. And that's simply incorrect. All wages, including overtime, should be included in the gross wages. Another typical error we see is when there's been less than a year's worth of earnings before the injury date. And the adjuster, instead of taking the actual number of weeks worked, for example, if there were 25 weeks of earnings before the injury date, the adjuster may take the yearly earnings for the period of time before the injury and divide that by 52 weeks. And that's going to result in a much lower compensation rate than what it should be. Another hidden claim involves attendant care. If the treating physician has ordered that the injured worker have in-home services, for example, care for daily needs or medical attention, and that service is provided by a spouse or another loved one, then that person providing the care is entitled to be paid just like a regular professional would had they been providing that service. The last hidden claim involves a 10% penalty payment for a safety rule violation. If the employer intentionally disregarded a safety statute or an OSHA regulation and that resulted in injury, then that could result in a 10% penalty in addition to the regular compensation rate. Unfortunately, late wage replacement checks seem to go hand in hand with having a workers' compensation claim. I recognize this can be terribly frustrating when you have to pay the mortgage, put food on the table, put gas in the car, and pay other bills, and not to receive your check on time. This is why our office, we do everything in our power to make sure the adjuster issues the checks on time. And whenever we hear about our client not receiving a check, we're going to make phone calls, daily if we have to, send emails, and contact the adjuster until we know that the check has been issued. There are situations in claims when an injured worker can handle their claim without an attorney. These are situations such as minor injuries, injuries that do not result in permanent restrictions or a permanent injury, limited medical treatment. However, there are certain types of claims where I feel strongly that someone not only needs to consult with an experienced attorney, but needs to retain the attorney to help conclude their claim in a matter that is fair and just. The first type of claim, when someone needs to retain an attorney, is when the injured worker, after they're through with their medical treatment, will end up with permanent work restrictions that will prevent that worker from returning to work at their previous position. And this is a situation where someone, a worker, may either lose their job or be asked to go back and perform another position that they were not doing before. In this type of case, the insurance company can require the worker to participate in what's called vocational rehabilitation. And this is an attempt to try to find the worker another job with another employer that is within their work restrictions. There's going to be a vocational counselor that's going to be retained by the insurance company whose job is going to be to help find that injured worker another position. In this case, the rules change, and there is a lot of pressure for the injured worker to find another position. That's why we meet with the vocational counselors to make sure that all the rules are being complied with and that the vocational counselors are not identifying jobs that are not appropriate for that worker. Whenever a workers' compensation case is going to be resolved by what's called a clincher agreement, the injured worker needs to be represented. A clincher agreement is basically a global settlement that the parties enter into that will end the claim. Once the injured worker signs the clincher agreement, the employer's obligation to pay for medical treatment, pay wages, pay for any permanent disability is over. Whenever a case is going to be resolved by a clincher agreement, the insurance company and the employer will hire their attorney. The attorney's job will be to protect the interest of the insurance carrier and not the injured worker. I feel strongly that whenever an employer retains an attorney, the employee needs to be on a level playing field with the insurance company. They need to have their own attorney who is looking after their interest and is not going to let them enter into an agreement that's not fair, that doesn't pay them, each and every benefit that the workers' compensation carrier is obligated to pay. We do not let our clients enter into unfair agreements. Whenever there's a third-party claim, an injured worker needs to have their own attorney. A third-party claim is when the accident or the injury is caused by the negligence of another party. And by that I mean the negligence of someone other than a co-employee or the employer. The best example of this is when someone has to drive as part of their job. And if they're in their vehicle and involved in an automobile accident that's caused by the negligence of another driver, they will have a claim against both the workers' compensation carrier and the liability insurance carrier insuring the at-fault vehicle. So there's two different insurance companies involved, and the rules get complicated. I do not believe a worker can effectively and fairly resolve both claims in this situation. The last type of claim is when an injured worker is receiving both workers' compensation and Social Security disability. In this case, there are federal rules involved that affect how a case can settle. And because the rules get complicated, if someone enters into an agreement without being represented, they could lose valuable Social Security and Medicare benefits. Thank you for allowing us to come into your home to provide free legal information regarding a workers' compensation claim. I understand that if you're watching this informational DVD, chances are that either you or a family member or a loved one has been seriously injured on the job and are facing being out of work and the need for medical treatment. I also know that you would much rather be back to work, doing your old job without restrictions, without having to rely on an insurance company to issue wage replacement checks on time and to provide medical treatment for your injury. Should you decide to hire the Whitley Law Firm, it will be our honor and privilege to represent you. We will make sure that your rights are protected, that you receive each and every benefit that you're entitled to. We promise you that we'll make sure that your voice is heard loud and clear.